Welcome and bonjour à tous et à toutes here in Brussels and from Brussels to everyone who's watching online on the International Data Protection Day. I'm very sure you're not wondering in which session you are. We already had our fantastic chair from a committee introducing us, which is really nice. It's main session 2, What's in Your Mind, Neuroscience and Data Protection. So we had been looking at a broader picture before in the sessions before that, and now we are turning our view more inside. Or it used to be in a galaxy far, far away. It is a period where mind reading has just been established and people can control prosthetics with their mind. But with the help of generative AI and fast evolving neurotechnology, we are actually leaving the science fictional world, and we have the metaverse looming. We have, I learned, airports possibly coming out that may read your brain activity already in the near future. And we have stepped now into the very real world with all the ethical and legal challenges that this presents and that we will explore in this panel. My name is Elsa. I have the honor to be the previous chair of the Consultative Committee of Convention 108, and I will be your moderator for this panel. I think our current chair already reiterated what the convention is about, whose 44th birthday they are celebrating today, and La Grande Dame continues to be relevant. The committee continues to work on guidelines that are freely available on the website in the areas of big data, artificial intelligence, profiling, facial recognition, digital identity, political campaigns, vote and elections. And let me just highlight one point, because I think we're rather in an EU context here about the convention. I think the convention is not always in the limelight because we have a GDPR, we have a law enforcement directive on the EU side. So we don't realize that this is also an implementation of a convention. And what is a singular aspect of the convention is that it applies to all data processing for all purposes. So it also is for purposes of national security and national defense. And that is something, a very singular aspect. So it's really good to keep that in mind when thinking about data protection. We have now challenges related to these neurotechnologies, which are unprecedented, and we want to explore in the next hour. This is why the Council of Europe, and let me take the opportunity to also explicitly thank the Council of Europe for hosting this event, and of course my thanks to the EDPS and the CPDP. I think it's a fantastic conference so far. This is why in the Council of Europe Reykjavik spirit, I think you heard about this in the morning, we brought you a panel on neuroscience and data protection, during which we will also look into the future. I think you will hear about some very cutting-edge issues where the new standards based on our common principles and shared values must be set and adjusted for an entirely new technology to be applied to our neurosystems and brain. With that, I will no further speak myself and jump right into welcome with you our panelists. We will do two short rounds of questions and hopefully also have a third round with you and the opportunity that you can also ask questions. I will introduce each panelist as they first take the floor. And first we have Marcello, Professor Marcello Ienca. He's a professor of ethics of artificial intelligence and neuroscience, the School of Medicine and Health. It's a technical university in Munich. He's also the deputy director of the Institute of Ethics and History of Medicine, also at the Technical University of Munich, der TU München. He has is a current lead of the International Brain Initiative representing Switzerland at the OECD at the production of guidelines on responsible innovation. We will hear about those also from Limor later on, and served as an expert on the advisory committee on the UN human rights and also for the Council of Europe. Marcello, I'm very happy that you could join us. You're one taking us into the brave new world on neurotechnology and the new developments. The floor is yours.
Yeah, thank you very much, Elsa, and also an extended thank you for having me on this panel. I guess many of you are probably wondering at this stage why on earth there is a panel about neuroscience at Data Protection Day, especially considering that it's between you and your lunch. So I'll try to make a case of why it is important to talk about neuroscience at Data Protection Day. And the primary reason is that we all have a brain. And this brain, historically, if you look at human history, has been a black box. So we had no way to understand what was going on inside the brain. We could guess it based on behavior. We could guess emotions and things like that. But we simply lacked the basic technology in order to see and read and understand what's going on inside the brain. But now we are starting to develop these technologies. They're called neurotechnologies, so technologies that can interface with the brain with the purpose of reading out from the brain and also to rewrite the brain, because the brain information is not in a read-only format. It can also be rewritten using techniques like neuromodulation and neurostimulation. The important thing I think that needs to be clarified up front is that the brain is the largest data repository on this planet, actually on the universe, because it is the most complex organ. It is the most powerful processing unit that we have, and therefore gaining access into the brain and its inner working is revealing vast amounts of information, including highly sensitive information. And artificial intelligence is a catalyzer of this process. So neurotechnology started to develop in the 70s. We had the first human implants in the 1990s. But now we are at the stage where we're refining not just the hardware, so the electrodes that are needed to read information from the brain, but also the software. And in fact, advances in generative AI, including large language models, are extremely powerful at revealing information from brain activity. Now, what does it mean to read out from the brain? Elsa mentioned mind reading. You know, this is a concern that is often seen in the science fiction books. Is that reality? I think the answer is it depends. What do we mean by reading, right? So when the metaphor stays for, you know, just like in the same way we read a book, when we read a book, what we actually do is we look at symbols, which are written text, so alphabetical or ideograms, and then we convert those symbols into meanings. Is that something that we can do in neuroscience? Yes. So what we do is we convert quantitative measures of brain function, such as electroencephalography or functional magnetic resonance imaging, and we convert them into meaning, including meaning about a person's mental states. What we cannot do is to read the full language of thought. But I want to point out two things here. First of all, not all privacy issues related to neuroscience have to do with mind reading. So with decoding mental states. So if you have something like biomarkers of schizophrenia or Alzheimer's disease, that information is not revealing your mental states in a narrow sense, right? I don't know your thoughts. I just know that that piece of information, and it doesn't necessarily have to be, you know, information from a medical examination. We can actually now predict a person's probability to develop dementia just based on their stroking behavior on a touch screen of a smartphone. And that information is highly revealing, because if, you know, you find out that I'm about to develop early onset Alzheimer's disease in the next 2 years, you know, that information, if it falls in the wrong hands, it can lead to neurodiscrimination. So this is the first point. Privacy in the context of neuroscience is important because it can prevent new forms of discrimination based on neurological or psychiatric features. The second point is that mind reading is not necessarily bad. So we do need to read minds in order to understand how the brain works and develop tailored solutions for people in need, especially in medicine. There are the recent data that showed that 1 in 3 people alive today is going to develop at least one neurological disorder in their lifetime. And 1 in 2, so we're talking about half of the world population, is going to experience at least one mental health condition in their lifetime. And we cannot cure what we cannot understand. We cannot understand what we cannot measure. So we need to collect data about brain activity, structure, and function in order to develop better solutions in neuroscience, in medicine, and so on. But we need to be very careful about gatekeeping. We need to decide who gets the right to read brains, because now we are seeing that this ecosystem of neurotechnological applications is spillovering onto the consumer sector. So they are no longer confined in the field of biomedical research and clinical medicines, but we have an entire growing ecosystem of consumer-related or consumer-graded neurotechnology applications. Many of you are familiarized with the topic with Neuralink by Elon Musk, but the ecosystem is big, and the entire big tech sector is now tackling quite heavily on neuroscience in order to embed brain activity information into the big data repositories that they have available. So the challenging question is the question of gatekeeping. How can we maximize data processing and data sharing in neuroscience for the benefit of humanity while preventing certain types of risks related to the unconsented revealing of mental information, such as emotions, memories, and so on, from people, considering, and I'll conclude here, that the technology industry in this particular sector is quite aggressive in the attempt to obtain information about people's minds. The entire data economy is an arms race to people's minds, to people's attentions, to people's intentions, to people's desires. So if we can gain that information at the source, at the underlying neurobiological processing of our intentions, desires, and predictions, then that information is, in my view, highly sensitive and needs to be protected, and we should decide who the gatekeepers of that information should be, also considering that many people involved in collecting data about the brain also seem to have a massive interest in influencing behavior at the large scale. And probably many of you know what I'm referring to. So I'll stop here.
Perfect. Thank you very much, Marcello, for showing us. I think there are a lot of lawyers in the room as well for showing us what is out there in the world and very real developments and very real risks as well. So next one will be Anna Austin, Jurisconsult of the European Court of Human Rights. Anna, you have worked as the head of division in the registry of the court for 10 years, and you're currently the court's deputy jurisconsult. So I'm so sorry. I was referring. I will start again. Next will be Anna Austin, Jurisconsult of the European Court of Human Rights. You're a qualified solicitor, joined the European Commission for Human Rights in 1994, the European Court of Human Rights in 1998, Deputy Ombudsperson for Bosnia and Herzegovina in 1997, headed the Office of Investigating Judges of Khmer Rouge Tribunal in Cambodia 2008 and 2009, in charge of human rights issues in the Secretariat of Committee of Ministers in the Council of Europe in 2014 and 15, and acted from 2013 to 15 as the legal advisor of an international advisory panel on Ukraine. Anna, we're very happy that you're here. Could you give us a brief insight in your role in the court and what are your views? What could be the possible case law in this area?
Good morning, everyone. Can you hear me? I think we've got about 5 or 7 minutes. So the convention in neuroscience, go. I thought that I'd probably break the tension straight away and say there is no obviously direct case law on neuroscience techniques because it's all emerging. The convention celebrates this year its 75th anniversary since its adoption. And one would think that perhaps the concepts foreseen in the late 40s couldn't possibly be adapted or used to the kind of world Marcello has just sort of introduced us to. But the reality is the world has changed unrecognizably in the last 75 years, and the convention has applied to all of those evolutions, I would suggest, relatively effectively, at the very least creatively and imaginatively. So this morning, I thought it would be perhaps useful to have a quick look, explore at the potential protections in the convention, and perhaps certain convention concepts would embrace certain neurological techniques, whether it be reading or indeed treating the individual via that. And perhaps maybe this morning I'm going to raise more questions than I answer, but that's why we're here, I think, as well, particularly at this stage of the game. If I could just say, one of the roles in Jurisconsult work is to share knowledge. And one of the things we're doing is we're keeping an eye on emerging themes. So what we're trying to do in terms of sharing knowledge in the court is to have keep an eye on three things. The likes of yourself, Marcello, what are the emerging technical issues? Speak with our domestic courts. We have a network of 110 national superior courts. See what issues are on their dockets. And thirdly, keep an eye on doctrine, so that when the issue arises to us, because we are last in the chain, we will have some idea of the emergence already of the issues. But I wanted to have a quick look at some convention concepts, perhaps to bring some comfort that there is some good old-fashioned protection to be had. The first one is the question of the voluntary nature of, or your waiving of your rights and volunteering to be the subject of this kind of neurotechnology. Interestingly, the court has a very tough line of case law on waiver. It has set out a whole list of criteria by which it tries to establish, is a waiver of your rights legitimate? It needs to be unequivocal, it needs to be fully informed, and the person needs to be fully informed of the precise consequences of the particular process, which at the moment I'm not quite sure that even those technicians who know the processes are quite sure of the consequences. So I think the area of waiver and the acceptance of waiver is something the convention has been very strict about. Secondly, the convention has actually said there are rights that are so important you cannot waive them. The obvious one is the protection against torture, inhuman and degrading treatment. But the less obvious one, which makes one reflect, is, for example, you cannot waive your right to an independent trial, which sounds like a subtlety, but of course, it shows that there are certain rights that are obvious but fundamental to other rights. That means you can't waive them. In other words, it seems that in this area, it will be very difficult to have a full voluntary, for now, waiver of rights. So the full protection mechanism would apply. So let's look at about 3 or 4 convention subjects to see how they can be adapted. There is the protection against torture, inhuman and degrading treatment, always flouted as the absolute right, but is it? And the application to the neurotechnology can be relatively obvious when you see some of these cases. But the first nuance that renders it less absolute a protection and perhaps more applicable in this context is the question that of therapeutic necessity. So that if medical diagnosis requires this form of therapy, then that, even if it would have a profound impact on the individual, can be justified, and therefore can lean in favor of some level of neurotechnological treatments. Interestingly enough, case law that talks about forced medical intervention to find evidence to assist with a prosecution, again, that is possible. There are, of course, limits put on it, but one needs to think about that in terms of mind reading for the purposes of criminal prosecution and the availability under the convention of certain proportionate use of that, even if in theory it would amount to undignified or degrading treatment. Protection in Article 6, and this is the great one, the right not to incriminate oneself. What if the technology can read your mind? And when I was reading all of this case and I was trying to find an answer, what actually was interesting was the whole justification for the right not to incriminate oneself was actually to ensure that you would not be improperly compelled to do so, and therefore to protect against ill treatment of the detainee in front of a police officer. Well, if you can eliminate the risk of ill treatment by the interrogating police officer, because you can put an electrode in some, I'm sorry, that's simplistic, but because one can read the mind of the accused, then does the right against self-incrimination remain as the protection for the accused? And actually, it's very difficult to go beyond our case law and get right to the back of, is it a philosophical statement in the convention, namely the right to silence or not to incriminate oneself, or is it a pragmatic one to prevent abuse, in which, in the latter instance, then perhaps the protection of the convention would allow some level of mind reading for the purposes of criminal prosecution. I'm going really fast here because we have to be, but these are the kind of issues that one looks at in convention terms. I won't even bother with Article 8 and the right to protection against privacy, because I think you have explored that already this morning and you'll explore it in the afternoon. But look at the concepts that are covered by privacy: personal autonomy, physical and mental integrity, and dignity. And the dignity aspect is something that has been more and more present in the court's case law. And I think this is something that will have to be grappled with in when the technological possibilities are there. Privacy and legitimate expectations of privacy is something that the court has developed recently, particularly in the digital world. And the whole issue of informational self-determination, that is something that is developed in the case law, and it is something that will provide a certain level of protection. But so much for the right to privacy, I won't go there anymore. What I wanted to do was to reference just one case, because let's keep it sort of real, because I think it's good to have a real case. And this is the Essen Marper case from 2008 against the United Kingdom. And this was the issue of data, DNA data, and the level of protections and overlay of protections that the court came up with to protect that sort of data, which is very similar to the reading of the data in one's mind. There's two other rights unexplored which may become hugely important in this area, and they're negative rights. And one of them is the absolute right, which is the freedom of thought. That is the only right under the convention which scholars, I say scholars because we have very few cases on it, have indicated is the absolute right. It has come up from time to time as an indirect issue in case law, but hasn't been fully decided. The other negative right that's going to be a source of some protection is the right not to express oneself. And this has been finally ruled upon last year by the European Court of Human Rights. And I think these two lesser known and lesser used rights would probably be the source of much of the new protection in this new neurotechnological era in which we are leading into. I will leave it there if that's, I hope I'm in the time, and obviously can deal with questions later.
Yes, thank you very much, Anna. And indeed, I'm German, so I'm trying to be a strict timekeeper. But no, thank you very much. And I think raising questions, but also giving us hope that the principles we already have are able to develop and to deal with these emerging challenges we are having. So next one, it's my pleasure moving on to Limo Schmerling-Magazanik, and I'm sorry if I'm not pronounced that perfectly.
That's perfect.
Okay, right, great. She's a member of you're a member of a data governance expert group from the OECD. So you work at the OECD on issues of privacy, data governance, and digital security. You currently also lead the work stream on health data governance, which includes a program on neurotechnology and privacy. And you have before managed a tech policy think tank, and you were head of enforcement for Data Protection Authority, and as well an academic lecturer. Limo, the OECD has done work in this area, so if you could tell us some more, we would be very interested. Thank you.
Thank you. Thank you. It's wonderful to be here and in this very distinguished panel. And share some thoughts. So a couple of short words about the OECD, the Organization for Economic Cooperation and Development, and it's 38 member states from different continents around the world with different viewpoints and jurisdictions sometimes. And I think that the main thing that would be characteristic is that we aim to support better policies for better lives from a very economic and social perspective. And we look the same way at the digital transformation and making the most of it. And also in neurotechnology, I think it's very much an art or a big effort of getting the benefits while mitigating the risks. I think I was reflecting on this all morning, coming here to Brussels and even getting up here on stage and realizing I have both my iPad with my comments and my small notebook with my outline, which I was reluctant to give and are trying to hold both ends. I think it's quite a difficult, it may be telling of my age a little bit, but I think that the work of tech policy is very much trying to hold both ends. And neurotechnology is one of the more compelling cases because the benefits promise to be great. We already have a lot of evidence in the health space, in the health sector, where the benefits are quite great. A lot of research already indicating success in both treating Alzheimer's and Parkinson's and epilepsy and many mental health disorders, and with having a population that is aging very fast and a lot of neurological disorders that need tending. So there's a lot of potential here. At the same time, just from speaking about this, we feel it in our stomachs. That is, the risks are very high and the potential for harm is grave. So it's quite a complicated art, and we've been trying to do this to address this at the OECD in supporting the government delegates we work with already in 2019 by creating a recommendation of the Council of the OECD on Responsible Neurotechnology that some of you may know and have participated in the work for. And it is now currently these days, 5 years after its confirmation, being revised. And we're thinking about how we might supplement, update, change it because the times are changing, because the technology is moving so fast. And we also house at the OECD the famous privacy guidelines from the 80s, the privacy principles at the bedrock of many of the privacy legislation and regulations that evolved later on. And what we're trying to do currently is work together in both working parties to combine the outlook of these privacy principles together with responsible neurotechnology. And I'll start with mentioning one, I think, distinction of the recommendation on responsible neurotechnology about holding both ends. So it calls for safety in the application of this technology, but also for its promotion in an inclusive way, since when there are lots of benefits, when we want people to be able to enjoy all of these benefits equally and to have them available to all who need them. And we want to promote scientific collaboration as well as societal engagement and deliberation. So trying to support the development of the technology and its implementation for the good, but also to speak with people, with patients, with stakeholders about the potential huge risks that we want to address. And I will skip and maybe dive into the privacy part, which currently is a section of the recommendation that resonates, I think, in this audience. So it calls for provision of clear information to people in order to ensure consent and protection of autonomy. And I think autonomy for me is the main keyword when we're talking about these types of technologies, to maintain the autonomy of people, whether it is in the processing of the data, but also in the application of the technology on their self, on their being, on the medical treatment. And We also find, of course, the protection of confidentiality and privacy and the traceability of the data collected, not only the data that can represent thought or ideas or medical information, but also the data that documents the medical act itself. So it is also possible to know that a medical act, a neurotechnology has been used on a person through the reading of all of this data. So this also supports our ability to maintain autonomy in its application. And maybe being the OECD, I have to, I think I am responsible to give some data points and stats, even though we did not collect them at the OECD. So this is market research by private firms, but it is estimated that in the past 2 years, this market has arrived at 15 to 17 billion US dollars. And is expected in the next 5 years to grow to 30 billion, and in the next 10 years to 50 billion US dollars. And the United States represent currently 36% of the market, with Europe quite close at 30% of the market, and Asia Pacific 24%. So we're seeing quite a potential big market growing, and we can hear and imagine with all of this need for support of healthcare that it will continue to grow. One of the interesting things that has happened, and I do not have data about this, and I think this is quite important, is that there are, let's say, reports of this technology being investigated in other sectors. So while the healthcare sector is quite a compelling use case, when we're talking about this technology entering into education to monitor alertness of students or efficacy of efficiency of teachers in teaching, or monitoring employees in the workplace, are they alert and are they functioning and producing, or to monitor other spaces as commerce and immersive gaming, then it's starting to be different. I think we may discuss and explore this later in the sense that the formula for the risk scenarios, the different risk scenarios, the risk management starts to be different, and we need to perhaps remember, if we're thinking about governance frameworks, regulatory frameworks, with emerging technologies, we want to maintain agility. We want to maintain the ability to swiftly react to the advancements of technology on the market. So when choosing the relevant regulatory approach and tool, we need to explore and close this gap between our suspicions and the knowledge of what is actually happening. I think this is true to enforcement work and judicial work, and also governance and regulatory development work. So I will close with this, and thank you. And
Thank you very much, Limor, also for giving us the stats of the OECD, underlining also what Marcello already said in the beginning. Next, I will move to Alessandra Pirucci. She has been the chair of the Council of Europe Consultative Committee of Convention 108 for the last 3 mandates. So you have the chairs of the last decade actually here during the conference. She's still a bureau member. We're very happy to have her. She's a lawyer and has been working for several years at the Italian Data Protection Authority in EU-related and international matters, and particularly coordinating the work of a subgroup on data protection and financial sector. Alessandra, you're not only the former chair, but you're also the rapporteur for the current work done in the consultative committee of a convention. What is going on in the committee? You have the floor.
Thank you, Elsa. Thank the organizers, of course, for the invitation. I'm absolutely honored to be here in such a great event and on such a significant date. And yes, Elsa, what I will try to do is to give the perspective of the Council of Europe in respect of neurotechnologies, a Council of Europe whose activity I had the privilege to follow since many years, being a member of the Consultative Committee of Convention 108, as you recalled. And I would would start saying that the Council of Europe is really a privileged observatory to explore the many challenging issues that raised by neurotechnologies, and this for a number of reasons. Well, first of all, because it is very much in the visionary spirit of the Council of Europe to explore new frontiers of law, and neurotechnology is definitely a new frontier, because the Council of Europe activity is based, of course, on the European Convention on Human Rights, and this allows an observation of new phenomena like neurotechnologies through the lenses of the several human rights at stake, in a sort of a comprehensive vision that is really indispensable here. And finally, because there is a great need for global standards, being the development of neurotechnologies really transversal, considering the wide range of countries which are considerably investing on the issues, as Limor was saying before, and also considering the various legal answers which are coming from different countries, sometimes also according to different models. I'm thinking about Chile, for example, with the constitutionalization of neuro rights. I'm thinking about other models, such as US countries which have opted for, let's say, the explicit extension of the protection of personal data to neural data. And against this variegated background, within the Consultative Committee of Convention 108, we started reflecting on neurotechnology with the great support of two authoritative experts, Eduardo Bertoni and Marcello Ienca, who elaborated a very interesting report on neurotechnologies in the perspective of Convention 108 and Convention 108 Plus. It's a report which was also the outcome of the exchange with the Consultative Committee and was published after the plenary last June of the committee, and it now constitutes the basis for the guidelines on which the Consultative Committee is working. And with the two experts, we started from the conceptualization of mental privacy, which really is the most sacred form of privacy, the cognitive intimacy, I would call it, really the home of our thoughts and feelings, which is now subject to unprecedented in interference and intrusions, which somehow brings us back to the core of Article 8 of the European Convention on Human Rights, which gives, as you all know, protection to forms of intrusions, traditionally by public bodies, but then more and more by private parties as well. And within the Consultative Committee, we also moved to another, by now quite classical debate in neurotechnologies, whether we need new neural rights or, on the contrary, being aware also of the risk of rights inflation or neuro-exceptionalism, whether we should rely on existing rights. And the kind of perspective that we embraced is that, let's say, before engaging in the creation of new neural rights, it is crucial to prioritize a very rigorous and attentive interpretation and application of existing rights, which of course does not exclude that further acts and guidance could then intervene, but really built upon the solid interpretation of the precious heritage we have. And the reference to the existing framework, I think, is also essential for a very pragmatic consideration that the elaboration of new rules takes time, and neurotechnologies are developing incredibly fast, and we cannot afford to leave room to a non-disciplined evolution which does not consider a human-centric perspective, as the rules would then be likely dictated by, let's say, prevailing commercial purposes. And in this respect, I think that the evolutive interpretation of Article 8 of the European Convention on Human Rights, which was expanded already to cover integrity, including mental integrity, and Article 3, as Anna also mentioned, the prohibition of torture, which allowed the enhancement of the protection of mental integrity, are really indispensable parameters to build upon the future safeguards, but also to eventually set prompt bans for unacceptable practices. And in respect of the data protection challenges that we explored so far at the consultative committee, of course, there is no time to go through the whole set of provisions of 108 plus that we examined, but just let me quote a couple of them. Of course, we examined consent and the, let's say, obtainment of a truly informed consent is, of course, challenged by the unique nature of neural data, which often involves the recording or the stimulation of brain activity directly and actually below the threshold of conscious awareness. And I cannot anticipate already the position that the consultative committee will take in this respect, but for sure I can anticipate a lively debate on legal basis of neural data. In particular, on whether, for example, consent should be considered as a sort of preferred legal basis, being neural data so much rooted into the intimate sphere and the consciousness of the individual, and actually being also central to other relevant tools such as the Oviedo Convention, and whether on the contrary consent already shows evident limits that I mentioned, which cannot be neglected and are exacerbated in neuroscience. And one thing I think it is important to recall is that we should always remember that consent cannot legitimize what is against the human dignity and human rights. And just one last word, if I have 30 seconds, just to mention that we also examined a risk assessment, well, considering the wide range of technologies, of neurotechnologies, and the risk of misuse of such technologies and data, a risk-based approach of these technologies is essential, similarly to what we have learned doing for artificial intelligence. And this is why in our work we explore the concept of a mental privacy risk assessment. And in doing so, we are somehow facilitated by Article 10 of Convention 108 plus, which somehow extends the assessment of the impact of data processing, not only on the protection of personal data, but on all fundamental rights in a sort of holistic approach, which I believe is particularly appropriate in this field. Thank you.
Thank you very much, Alessandra, for taking us through the work we're doing, but also to reminding us on what kind of principles are already laid down and within the current data protection regimes, and particularly the Convention 108 and 108 plus. So first of all, because the time is progressing, and I was very fascinated, I think, always to listen to everyone. First of all, I would ask the panelists, do you have like a pressing question you would like to ask each other after hearing you? If that is not immediately the case, I would open the floor now for questions from the audience, because I think that will be very interesting. I see a question there. Yes, please. And please state if you have a question for someone specific. That would be helpful. Perfect.
Hello? Yeah, there we go. So in 2015, the Article 29 Working Party, now known as the EDPB, wrote to the European Commission explaining that, and I will quote, data about persons' intellectual and emotional capacity, such as IQ, are health data. And we're talking here today about emerging technologies around neuroscience, yet the elephant in the room is we've actually been using these techniques unlawfully in the EU, ubiquitously almost, for an incredibly long time. Psychometric and testing of individuals candidates for recruitment under EU law would be considered as special category data, as health data. The only semi-appropriate legal basis for processing that special category data would be informed consent, or explicit informed consent. The problem with that is, when we're talking about recruitment, we're in an employment context, so there's an imbalance of power, which means that consent would not be valid. So how do we deal with existing uses of, or manipulation of people's neurology and testing of their neurology for the purpose of being able to engage in society and in the workforce? And how are we going to manage future technologies if we can't even manage the situation that we've had for decades now?
Thank you very much. Yes?
I can give it a try. It
Okay.
sounds like a good challenge.
Go for it.
I think I'll first look to one of the previous speakers who said that the first thing is to answer not the question asked. So I'm not going to do that, but I'm not going to accept all of the premises within the question. So firstly, I'm not sure that we're in a complete bankruptcy at the moment. We do have privacy regulations, and we have biomedical health regulations. Both cover the current processing of neurological data, of neurotechnology. I think the question here that we're currently asking is whether this emerging technology, which is jumping years forward and will be jumping even faster with AI, requires additional governance frameworks so we are better prepared for the future. I don't think we have zero at the moment. I would mention privacy by design, privacy enhancing technologies, methodologies that we already use today to protect many types of sensitive data, health data, other types of data in various sectors. We have regulations and methodologies in place. We might be facing new challenges. So we want to be better prepared. We want to brace for the future. But I think that is the premise that we need to start with.
Thank you, Limor. Marcello, or is there...
Yeah, maybe if I can follow up, I think that's a great question. But I do agree with Limor that I think we're not in a complete bankruptcy situation. But I think your question is also very interesting to ask ourselves to what extent brain data are different than other measurements that we already have, such as psychometric data, which are used for IQ testing, or they're used by social media platforms for profiling purposes and so on. And I fully agree with you that that's very sensitive information, but the magnitude of sensitivity of brain data, in my view, is exponential. Because in order to collect psychometric data, a participant needs to engage in behavior. You have to perform a test, whereas brain data can be collected in the absence of people engaging in observable behavior, which increases the probability that they could share information that is they're not aware of. And also a lot of brain activity happens below the threshold of conscious awareness, as Alessandra was mentioning, which makes it very hard to basically, we keep saying the best antivirus software is the brain, in the sense that, we can choose which platforms we visit, which sites we visit. In that case, we cannot make that decision because the information is being collected at the source before we can actually make those decisions. So I think we have a lot of elements of novelty, and also challenge a little bit the phrasing of future technologies as compared to technologies that we have today, because I don't think here we're talking about future technologies. We're talking about technologies that are already used extensively today in an increasing number of patients, but also in an increasing number of healthy subjects through non-invasive applications. So I think we really need to look at parameters of novelty. I think there is certainly a question of data volume and richness. Because, if we keep saying data are the new oil, I don't like this analogy, but if we buy it, then basically there is the largest ever oil reservoir that is waiting to be accessed, because, the amount of information that is produced in the brain if we quantify, neuronal firing as bits of information, then this is the largest ever data repository ever created. And this is there to be accessed, and a lot of people are waiting to access it. The second element is time, because when I started working in the space and we started doing the first assessments of, including privacy assessments in the context of neural data processing, often the response was like 7-8 years ago, oh, that will never be possible to read out that particular source of information, say, decoding dreams or decoding certain aspects of working memory. And then studies that proved the actual feasibility of doing that on a large scale became available 2-3 years ago. So in the neurotechnology space, never means 5 years, basically. And we have to be aware of this. And the last point, I think, is impact. Because we are not talking about, data like any other. Brain information is the most reliable data when it comes to predicting a person's future health and also predicting a person's behavior based on their preferences. And this information has obvious also political implications, because if we have access to a person's brain information, then we also have access to a person's cognitive or emotional vulnerabilities that can in turn be exploited. Because once we know that, then we can develop technologies that are designed to exploit those capabilities in a much more refined and sophisticated way than the data that we already have today. Because clearly psychometric profiling is used to influence people based on their vulnerabilities. But now we could do that in a way that is way more sophisticated, way more precise, and way more impactful.
Sorry. Okay. I think just for fairness chances, I would open the floor for maybe 2 more questions, and maybe you two can continue the discussion in the lunch break. I think that would be perfect. Wojciech, please. Are you, sorry, I will first take, and then I give the floor to you.
Okay, no, it is. Thank you very much for a wonderful discussion. Well, I'm not hiding the fact that I'm personally interested in the development of this knowledge, but I'd like to ask mainly probably the Professor Ienca on the problem of the synthetic memory. Because you were mentioning that in the report for the Convention 108 committee.
Well, that's a very specific question, and it's a very good one. So memory is one of the most complex cognitive processes we have, and therefore its reconstruction and revealing through the coding is the most complex. But synthetic memory also refers to the creation of artificial creation of memories. And I think there is extensive research in animal models that shows the actual feasibility of inducing even very specific and fine-grained memories, for example, in mice models. I do not expect that to be a technology that is available to humans in the near future. However, there is a potential need for that to the extent that we have, for example, a lot of military organizations that are operating in the space of neurotechnology, and they're working on technologies for selective memory manipulation. Why? Because we have soldiers that come back from the battlefield with post-traumatic stress disorder. So if we could intervene on memories and remove traumatic ones and potentially replace with non-traumatic ones, that there is actually a business proposition there. The extent to which we should do it, I think, brings us back to all the questions that my distinguished panelists were raising, with regard also to the implications for all the other rights. In particular, I think freedom of thought that Anne mentioned, which is a cornerstone. And I think this really goes hand in hand with mental privacy, right? So there is not much case law, as you rightly said, but there is a very long history of legal philosophy and philosophy of mind that shows the interconnectedness of freedom of thought and mental privacy. So we can exercise our rights to think freely to the extent that we can filter out selectively the information in our minds. Or did you have a question specific to any application of synthetic memory?
Well, of course, that's also connected with the question of reviving the memory of the, for example, of the witnesses in the criminal trial.
Okay. I think we have, sorry, one time for one more question. Yes, please, here in the front.
Hello, my name is Micah Ramon. I'm a professor and cognitive neuroscientist at the University of Lausanne. I have a question regarding the individual differences that I think are quite often glossed over. We talk about neurotechnologies as if we could predict and reconstruct content from individuals' brains very efficiently, whereas actually, in actuality, the scientific studies are based on group information from so-called weird samples, Western educated, individualistic, etc. So my question pertains to the level of specificity, because certain people will be discriminated against because they are simply not represented in the studies that are actually used and that form the foundation for this type of information that we can gather. So yeah, I would like to hear your opinions on that.
Thank you very much. Is a volunteer for this question on the panel? Limo, please.
I think I can very much identify and agree with where you're leading. I think that we need to be a lot more fine-tuned in our approach. So ask a whole series of questions when we're talking about data derived from neurotechnology. What type of neurotechnology are you using? We're using, in what context, on which people, what type of data is being collected, and then is this data personal data or identifiable data, and whom is it? And then create this whole matrix of, I think, spectrum that we as privacy professionals would look at and then need to adapt the relevant ethical or governance or regulatory implications to each of these slices of the very, very large pie. If you're, I'm not sure I understood, but if referring to the maybe homogeneity of data sets in the health data governance space in general, I think you were mentioning a very specific data of groups who originate in very particular places. That is another issue I very much agree with through my work on health data governance, that we know in health data research that we have a huge challenge, whether it's big data analytics or even genomic biosampling. If we do not have a representation, a diverse representation of population, we will not have equal benefits derived from whatever we're doing, whichever technology, whichever research, to the diverse population of the world. And there, of course, you probably know, there's a lot of research showing that our data sets are not diverse enough, and then therefore our conclusions could not be sound enough. So I agree with you both on the part of we need to do research on a diverse pool of representative populations, but we also need to apply data protection principles and the data protection matrix on a lot finer resolution of neurotechnologies and not put everything in one bucket. It's not just one bucket.
Thank you very much, Limo. Alessandra, you want?
If I just made some more words to what you were saying, yes, I also have the feeling that when we speak about neurotechnologies, we think about a huge box with many undifferentiated things. On the contrary, if we have a look at all the reports that have been produced on neurotechnologies, there is so much the need for classification of neural data, different kind of application applications. And I think what is also important to remember is that the sector in which neurotechnologies apply is particularly relevant. And also I go back to the first question that was raised, when we speak about employment sector, for example. It is true that the application of neurotechnology is susceptible to create incredible forms of discrimination. If we think about the possibility through neurotechnology to control the activity of the employee, even predict diseases which have not revealed yet. And to the employment, I can add other examples of other very sensitive sectors like justice, as it was mentioned before, or even education. I think we all read about the trial in China about the experiment on students of the primary school who had devices to be monitored in their attention. Well, in that case, I think that we should speak about quite bravely, also in terms of prohibition of what is against human dignity and human rights. Okay.
Thank you. I think we're very close to that the organizers jump on the panel to stop us. But I just want to, Anna, to give you a hard task at the last minute. You touched upon it. You said there's several points in the convention when you can use. Would you say that we would need a new framework, or is the convention we have sufficient? So if you can do this in basically 2 minutes, everyone would be very grateful.
I think from a substantive point of view, I don't think there is a need for a new right. I think if you look back again over the 75 years and all the digital technologies that have developed and all of the related issues, environmental issues, state responsibility for climate change, respect for animal rights, all these things that simply were not issues. So I think the rights can expand. But I think that the issue of regulation, the frameworks, the guidelines, the sector-specific rules, that needs to be done not only at state level, but needs to be done at the micro-state sector level for 2 reasons. One, institutionally, the court in Strasbourg is a fine-tuner. It assesses what has been done domestically, and it has to be done domestically. So institutionally, it's not the Strasbourg court that can find the solution, but actually a pragmatic problem which we've discovered in the digital world. Things happen extremely fast, and when the private sector get involved with science, things happen extremely fast. For the regulatory framework to keep up, and then at the very end of the line for the court in Strasbourg to get involved, it can be years later. And years, as you've just remarked, Marcello, years is huge in terms of this technology. So no, the right, the theoretical right is in the convention, but institutionally the frameworks that need to address it need to be at the micro and certainly at the sector level.
Thank you very much, Anna. And I think that is also a very good conclusion to this very interesting panel. I thank all the panelists, and I think you will join me in my thanks, and that will open the lunch break.